the court says is not inclined to impose any sentence of incarceration. So in other words, we're not going to put Trump in jail, but we are going to sentence him because we want that conviction. Findings by which the definition meant that he willingly ignored the order to be gagged. Trump continues to attack the unlawful and unconstitutional court because this judge is corrupt through and through. His daughter's corrupt and more. Whoa, we got good logic here? Huh? If the court is unable to impose sentence before Trump takes oath, this may become the only viable option. So this is also a warning, red alert on that. So if Trump appeals this and he's not sentenced, then over the 4 terms, the judge is going to come back down and just wait till the end. This judge is something else, man. Judge Merchan has now scheduled a sentencing date for President Trump, and it's coming up soon. And we've been saying there is no conviction here in this business records case because there was no sentencing that ever took place. But now the court is saying Trump must appear for sentencing on January 10th, 2025, 1 week from today at 9:30 in the morning to be sentenced in his court. We were wondering if this was going to happen or not because it was all held in abeyance. And in fact, they actually vacated the sentencing date and scheduled it for an evidentiary hearing. And then Trump's people submitted 2 motions to dismiss, one on the basis of immunity and the presidential transition, and other because there were errors in the underlying trial. The judge dismissed that underlying trial motion to dismiss, said that not denied, not granted. But there was the other motion that Trump is transitioning into the presidency. And so you can't hurt the president. You can't do anything to impinge on that transition, like, sentencing them and putting them in prison. Now, what has happened in this order is the judge is trying to be very sneaky. He is saying that when we sentence you, the court says is not inclined to impose any sentence of incarceration. So in other words, we're not going to put Trump in jail, but we are going to sentence him because we want that conviction and we cannot put him in jail. But here's what the judge says. He says, okay, look, on May 30th, 2024, not a long time ago, they were trying to race this through to harm Trump before the presidential election. A New York County jury, who are Democrats by about 70 to 80%, found Trump guilty on 34 counts of falsifying business records. The spreadsheet crime, which the government used liars to try to prove, like Michael Cohen and Stormy Daniels, came in and found him guilty. The deadline passed without the filing of any motions, deadline for June 13th for post-trial motions, but nobody filed anything. Then the court set down the matter for sentence on July 11th. Of course, that was adjourned. The Supreme Court came back down and said, yeah, we got immunity on this. And then the court postponed it. So then on November 10th, following the election, Trump won. Merchan says Trump requested a stay of these decisions because of the Transition Act. I'm transitioning into the presidency. And the judge said you can have some time to file your arguments. They've done that. Trump's people say, all right, listen, Your Honor, you cannot sentence me. There's nothing you can do. The presidential immunity doctrine, the Presidential Transition Act, and the Supremacy Clause require you must dismiss this case immediately. Trump said that his status as president-elect counts, and also the unlawful conduct by Alvin Bragg and his hack prosecutors violated Trump's rights, wrecked the trial, and they present legal impediments to conviction. You cannot convict him. The unlawful conduct that Trump alleges was the politically motivated targeting of Trump by Cy Vance, by the 2 whiny prosecutors who resigned in disgrace, Kerry Dunn and Mark Pomerantz, who both threw a hissy fit. Then Alvin Bragg changed his tune, got Matthew Colangelo over from Biden's DOJ to come over and help him start the case, saying they leaked info, they tainted the jury pool, they gagged Trump, they engaged in repeated misrepresentations to other, they suborned perjury from Michael Cohen and Stormy Daniels, brought them in to lie. Michael Cohen's a convicted perjurer, brought him in, lied anyways. Trump also accused this court of impermissibly presiding over this case because the judge's daughter works for Democrats and was raising campaign money for Democrats on the back of this criminal prosecution that was being conducted by her daddy. There was an unlawful gag order to talk about the judge's illegitimate daughter called Lauren, who was raising money off of these funds and these efforts. And Trump made a bunch of arguments. Now, the Alvin Bragg prosecutors responded. They said president-elect immunity does not exist. You don't even have it. And the vast majority of Trump's claims have already been rejected. And they said we can do some other things. How about we just adjourn sentencing until after the presidency? Just postpone it until Trump's done. Then we'll put him in prison later. Or they could impose the Alabama rule, which would abate the proceedings, right? We would just cancel the proceedings and then just basically terminate the case. Now, that's not allowed in New York. So the judge gives us some analysis here, says, okay, look, as indicated above, Trump has been found guilty on 34 counts, not sentenced, not convicted. The significance of the fact that the verdict was handed down by 12 jurors, he says, cannot be overstated. It was unanimous. The sanctity of the jury verdict and the deference to it is the bedrock principle in our nation's jurisprudence. Not when it's rigged, not a jury of your peers who hear evidence that is legitimate. The right to have a jury trial, he cites Blackstone, great, cites some other case law, great. Juries are important, don't get me wrong. Not in rigged jurisdictions, though. In fact, it is standard practice in criminal courts in this state to instruct jurors, you and you alone are the judge of the facts and blah, blah, blah. And so thus, we have to default to the jury. It's rare for a trial court to overturn a unanimous jury verdict. This is a rare situation. How many other instances in trial court practice have you had a sitting president who won? How about never, ever? So this is incredibly rare. It's understandably rare, and that's why you should do this now. They say also, Trump makes clear that the driving factor requiring a vacatur of the jury's verdict is he's the president now. So the primary issue, the judge says, is this question. Can a president-elect be afforded the same opportunity and immunity protections from state prosecution as a sitting president? Well, he says, as far as I can tell, there's no precedent for this. It's never happened before, except you guys are doing it. Although the parties agree on very little, they both appear ready to evaluate immunity. Though the parties arrive at different conclusions, they both rely on these cases as their legal authority. And other people have also brought up the Office of Legal Counsel memo. And remember, Jack Smith dismissed both of his cases, the J6 prosecution and the classified documents appeal, both gone, because they can't prosecute them. Even the Office of Legal Counsel said it. Now, as noted by special counsel's office when they dismissed the case, they said a fair reading of legal precedent says that you can't charge a president. But they said, oh, that's federal cases. So it's logical to infer that there's some overlap with state courts. And so they talked about it. Why won't the feds prosecute? They gave us a list of reasons and things to consider. And so he's saying, well, let's apply that to this. Like mental and physical burdens, witness preparation, all of that could impede the executive branch. You're not allowed to do that. So they say, well, let's apply that same analysis here. You can't prosecute at the federal level. Even Jack Smith and the DOJ say so. So how can I prosecute him here at the state level? Applying the guidance of the aforementioned cases, this court finds that immunity does not extend to a president-elect. Then no, sorry. You only get immunity after you take oath of office, and the president-elect hasn't done that yet. And so he's not allowed to avail himself of any protections of that office. Well, how come Jack Smith dismissed it then? This finding is consistent with other cases, and Trump's election team does not and cannot deem any of his actions official. And so there is no official immunity yet. So turning to the three concerns identified above, the case at bar is way past the initiation stage, and so there is no more public stigma for this, and so we can sentence him. One of his most frequent arguments is we should defer to the will of the citizenry who recently elected him. And he says, well, if they like you so much, they already voted for you, and so it doesn't matter if I sentence you. And also the third concern talks about the mental and physical demands on the presidency if the president has to deal with litigation. It imposes a burden that might impede the president. They analogize this to saying it's just like prosecuting a president. He's transitioning right now, and so you can't impede him during the transition. He says, well, I'm not persuaded by that. Having addressed and resolved most of these issues, they're all like half a year old anyways. The only thing left is a sentence. Scheduling sentence is a function that remains within my power, and I can easily put it at a date and time to minimize disruption and inconvenience. Now, prosecutor Jack Smith and his decision, why Jack dismissed his case, is different. Very different here because we already conducted a trial and Jack Smith did not. Now, while Trump claims that this court cannot and must not sentence him, the record is clear that he consented to, but requested this. Now, as the parties are aware, it was on Trump's application. They wanted the sentencing until after the election. And so since you asked for it after the election, you got it. But now he won. And so that introduces a new variable. Since he won, you can't sentence him. If he lost, you could have sentenced him. So Trump has always pronounced confidence that he would win. And guess what? He won. Oh, Mercan is so mad. He's like dripping with disdain in here. This is him saying, well, you're getting what you asked for, okay? He's pouting like a little child because that's what he is. That he would become the president-elect and that he would be required to resume all the responsibilities. He did win. Thus, it was fair for this court to adjourn the sentencing until after the election, and the decision decision in the Supreme Court case delayed the sentence, but it didn't preclude it. And so now we can sentence you now. He continues, the judge says, Trump prevents this court with a new novel theory, saying Trump wants presidential elect immunity and that it applies now. Well, this court is unpersuaded. You only get immunity once you're the president. It's not retroactive or anything. And what they say Trump is asking this court to do is to create something new. Two types of immunity. One when you're the president and one when you're the president-elect. And so I can't do that. I can't change those things. You're asking me to give you retroactive immunity. And so it would be an abuse of discretion now to give you immunity without any other legal authority. Trump has no argument to convince this court otherwise. Binding precedent does not provide an individual who becomes president with the ability to retroactively dismiss cases. Well, you can't sentence him. That's the problem. So the case is open. So the only other alternative, you don't have the Alabama rule, is a dismissal. So the case is stalled. You have to dismiss it. Now, part 7 of this is the Clayton motion. In addition to his claim that the presidential immunity and the supremacy clause warrant dismissal, he also says elect immunity matters. He submitted a Clayton motion, which set forth 10 factors the court should consider when deciding whether to dismiss a complaint and an indictment: the seriousness of the offense, the extent of the harm, evidence of guilt, history, character, condition of Trump, the serious misconduct on law enforcement, if that mattered, and more. Go through those factors and then ask, does this weigh in favor of a dismissal? A motion filed pursuant to that rule must be made within 45 days. And now Trump has become president-elect, and there's a new factor that has come in. So I can't submit this motion because this issue wasn't available at the time. Now I'm the president. Now I can bring this up, so now I'm doing this. But he says, sorry, you should have filed it later. Well, he couldn't because you were prosecuting him in the middle of an election. This is why you don't prosecute your political opponents in the middle of an election, because things change and it changes the analysis. So then he says, let's apply all those factors. He says, first of all, these charges are ridiculous. The fact that violent crimes are not prosecuted in the same courthouse doesn't mean these aren't serious crimes. So sure, they're not violent crimes, but there still was a 12-jury panel who found him unanimously guilty, which not really, by the way. Remember, they could pick whatever card they wanted, pick a card, any card, pick a crime, any crime, charge Trump with whatever you want, because they could find him guilty with whatever they wanted. Part of this was based on the fact that there were object offenses. They say Trump was concealing these business records to cover up for another crime. What was that other crime? Did it have to be unanimous? No, jurors could pick whatever they wanted. Could have been a federal crime, could have been a state New York crime, could have been a tax crime, even though nobody else brought any of those charges. They could have made it up and they didn't have to be unanimous. As long as they said there was some other offense, that was good enough, but they didn't have to agree on the other offense. He said it was premeditated. It was continuous. It was deception. This is Judge Merchan having a whiny fit, saying that the leader of the free world is the gravamen to this offense. To vacate the verdict on these grounds would cause a disproportionate result. Now, they also say that the evidence at the trial was weak. The judge says, no. I love Stormy Daniels. I'm very familiar with her work, and says that he also thought that Michael Cohen, a convicted perjurer, was a reliable source, saying as to the latter, the court issued its decision. We found that no official acts evidence was even admitted at trial, which is obviously a lie because there was a ton of it. They brought in White House employees to testify, Hope Hicks and Madeleine Westerhout. He says, well, that argument is meritless. Okay, as to the allegation that Michael Cohen is a liar, this court presided over the trial, and we sat mere feet from all the witnesses who testified. And so I got to listen to everybody, and doing so, I don't agree with the characterization of Cohen's testimony. You call Michael Cohen, who is a convicted perjurer, who literally lied either in this trial or in Tish's trial, and then lied about what he said to a federal judge in a different trial. So the guy's a bona fide liar, and the judge is like, he seems pretty reasonable to me. A total of 22 witnesses testified, 500 dumb exhibits, all supported the jury's verdict. They also say, let's talk about Trump's history. They say Trump has contributed way too much to this nation, too numerous to even reference. The court agrees, yeah, that the president did serve his country as president and will do so again, but that service as the president is only one thing to consider, so I have to consider everything else. They say that Trump's disdain for the judiciary, man, this judge is not happy, whether New York or elsewhere, is a matter of public record. He's gone to great lengths to broadcast on social media and other forums his lack of respect for judges, juries, grand juries, and the justice system as a whole. This judge is so biased, man, he should be recused immediately. Should have been a long time ago. In this case, despite repeated admonitions, this court was left with no choice but to find Trump guilty 10 counts of contempt for repeated violations of the gag order, because he didn't want him talking about his corrupt daughter. Findings by which the definition meant that he willingly ignored the order to be gagged. Trump continues to attack the unlawful and unconstitutional court because this judge is corrupt through and through. His daughter's corrupt and more. Whoa, we got good logic here? Huh? Check this out. Despite the fact that it has been challenged and upheld no less than 8 times, people are still bringing up gag order challenges. As indeed, as Trump must surely know, the same order was left undisturbed by the United States when good logic took it up to the Supreme Court. They're saying even the Supreme Court agrees with us because they rejected good logic's lawsuit. Well, that was his lawsuit, of course, not the judge's lawsuit. And so they might say that good logic doesn't have standing, whereas Trump may have had standing. So there's a bunch of issues here, even though I think good logic's brilliant and the Supreme Court should have heard it. But the defendant continues to undermine its legitimacy in posts to his followers, says that the posting indeed is not the only instance where he's violating the court's orders because they're unconstitutional. Trump has a First Amendment right to speak. We have a First Amendment right to hear. He says he keeps beating up the third branch of government and it does not weigh in his favor. So we're not going to dismiss this because he's mean to us. Saying also, were there any exceptional serious misconduct by law enforcement? Trump's people say, yeah, of course there was. There was false testimony that Alvin Bragg drug out of the porn star Daniels and the liar Cohen, and other misrepresentations by Bragg because they made Alan Weisselberg unavailable and prosecuted him with crimes to keep him off the board, unlawful investigative leaks, and more. Well, these arguments from Trump that the prosecutors committed egregious misconduct by bringing out testimony from Cohen and Daniels is unsupported. The court entertained countless arguments before this, talking about the parameters of testimony. If those rulings were violated, well, there were objections, and so I handled it appropriately. I gave curative or limiting instructions to the jury, and the jury credited the testimony of Cohen and Daniels and returned a verdict consistent with them. So the jurors who hate Trump all loved Cohen and Daniels. Now, further, this court does not share any hints about what they did to Weisselberg. The people unsuccessfully argued for the admission of his severance agreement, and I kept that out. So I did give you guys some wins, and so enjoy. Now, as for the alleged misrepresentations by Bragg in connection with the removal proceedings, I don't think those were misrepresentations at all. Those were rejected, and so we leave that there. Now, with respect to Trump's claims that there was an unconstitutional crusade against him, both claims have already been raised and rejected. Now, while significant portions of Trump's motion reference a book by Mark Pomerantz that he wrote after he threw his hissy fit, the court is not swayed. That former prosecutor Pomerantz wrote a book which is critical of Bragg, but it doesn't mean that it's unethical. Moreover, we've got Trump arguing the effect of imposing this sentence violates presidential immunity. The court rejects this claim, saying that it's consistent with the law. Analysis of this is already provided below. Now, Trump also argues that dismissal will improve public confidence in the criminal justice system. This perspective is different, though. The court is different. You say the jury pool was tainted. You've already raised this issue. And we did jury selection, and I asked the questions. And so I think that this was a fair jury. It's standard practice for the court to ask jurors to self-identify if they've heard about the case. Remember, they were trying to find Trumpers and throw them off the panel. Thus, while not particularly significant, we don't know how many prospective jurors self-excused. And the jury panel, where half its members self-identify as not confident, it's not uncommon. We have a lot of those things. So there was no bias. The attorneys did not question the jurors until after the jurors were seated. And so you got the jury you deserve. Now, while Trump is asking this court, what they're asking them to do is to determine that the jurors who identified as truthful were not. And so that's illogical and unconclusive, saying this would appear to contradict your stated concerns, and your conclusory claims that the jurors were tainted doesn't have any support in the record, and so they were fine. Also, Trump's claims about the jury pool are also unsubstantiated. As the court previously stated, claims of such nature go to the heart of the criminal process, and so when we consider juror misconduct, we must consider sworn allegations, and those have not been made yet. And finally, Trump alleges again that the public confidence has been fatally impaired by this corrupt court. But what he does not acknowledge is that he has made 3 applications to appellate courts, and those have been rejected. He's also gone to the ethics board, and they've rejected it as well. He's been aware for over a year that he continues to file, and judge calls them baseless attacks. They keep rejecting him because it's New York. To be clear, this is not the only example, says the judge, of Trump pursuing a claim with increasing indignation. He also filed a bunch of other motions like the unconstitutional continuation of the gag order. All that's going up to the Supreme Supreme Court. Shout out to good logic again. So how about the welfare of the community? Here, Trump says the welfare of the community is at stake, but there's no basis for this claim. And it's also appropriate to talk about his status as president-elect. To be clear, none of the concerns raised by the Supreme Court or legal counsel are relevant here. We've scrutinized all the positions, says the court. The court recognizes the importance of balancing these matters. The court simply is not persuaded that this outweighs what I have to do. So what, your president? I have to sentence you. His position is nothing short of outright and complete dismissal. The court has painstakingly considered these arguments, and we cannot set aside the jury verdict. To dismiss the indictment and set that aside would not serve any of the concerns of the Supreme Court. It would undermine the rule of law. Just as this court finds that his president-elect community is not actually law, I can't create that out of thin air. And so, since I can't do anything about this, we are going to sentence President Trump. Finding no legal impediment to sentencing and recognizing that presidential immunity will likely attach once he takes the oath, he doesn't have that now, it's incumbent upon this court to set this matter down for the imposition of sentence before he takes office. I have to get him before he takes the oath. It is this court's firm belief that only by bringing finality to this matter will all three interests be served. A jury heard evidence for nearly 7 weeks and gave us its verdict. Trump and the people were given every opportunity to exhaust their emotions in this unprecedented, likely never to be repeated legal scenario, but the judge is just going to sentence him anyways. The court must sentence Trump within a reasonable time following the verdict. He's appealed and he's tried and tried and tried, but nothing has happened. So now I'm going to give him 7 days so that there's no time to go to the Court of Appeals or go to the Supreme Court, and you're due for sentencing. This court has also now considered the Alabama rule, which is what Alvin Bragg was lawlessly promoting, to just terminate the case without any sentencing. The court has also considered the alternative proposal of holding this case in abeyance until Trump's term is over, and then they can just sentence him to prison when he's done. The reasons are obvious. If the court is unable to impose sentence before Trump takes oath, this may become the only viable option. So this is also a warning, red alert on that. So if Trump appeals this and he's not sentenced, then over the 4 terms, the judge is going to come back down and just wait till the end. This judge is something else, man. Now, while this court, as a matter of law, must not make any determination on sentencing prior to the parties and the Trump being heard, right? I can't make up my mind until I hear from you. It seems proper at this juncture to make known the court's inclination to not impose any sentence of incarceration. So it's okay if we sentence you and convict you, but I'm not going to put you in jail. A sentence authorized by the conviction, but one the people can see they no longer view as practical. So even Bragg's like, well, we can't put you in jail. As such, in balancing the considerations, when the underlying doctrine of presidential immunity, a sentence of an unconditional discharge appears to be the most viable solution to ensure finality and to allow Trump to pursue his appellate options. Unconditional discharge. So he'll be not serving any penalties, like not on probation or anything. You're just convicted and found guilty, so that there's no continuing penalties, like you don't have a probation officer, you're not going into custody, you're just convicted, and then he can appeal, right? So then we're just going to say you're done, the case is closed. We're not going to impose any penalties or anything really, but you are going to be sentenced. And I'm telling you what the sentence is. Now, further, to assuage Trump's concerns regarding mental and physical demands, this court will permit him to appear virtually for the proceeding, just like Ray Epps. So he can just call in and just say, oh yeah, just sentence me, perfect, no problem, if he chooses virtual meeting, and it's not even going to be that big of a deal. Just have to show up for 5 minutes, because being sentenced for a felony for something you didn't do is much easier on the brain and the soul when you can zoom in on it. See how that works? This is a joke. So in conclusion, the court writes, the court finds that neither the vacature of the verdicts nor dismissal of the indictment are required by presidential immunity, the Presidential Transition Act, or the Supremacy Clause. The court further finds that Trump arguments, whether independent or considered together, are factors A through J are unpersuasive, and so we're not going to be dismissing this case. That would be an injustice. We also find there's no legal impediment to imposing sentence under the law, and so it is hereby ordered that Trump's motion to dismiss the indictment and to vacate the jury guilty finding is denied, and it's further ordered that Trump must appear for sentencing either in person or virtually on January 10th, 2025, 1 week from today at 9:30 in the morning at New York Courthouse. Trump may also choose to appear virtually if he wants to, and you're directed to tell the court if you're showing up or not by Sunday night. The foregoing is the order from the court. Judge Juan Mercan, one of the most corrupt judges in modern American history, is now saying Trump must appear for sentencing.